How many times does argument happen? What does the courtroom proceeding look like? Even in a day, if the court has 60 matters, how many are going to be heard on the merits?
So it depends on the day of the week. It depends on the court you're talking about.
Where do you network? How do you network? Do you give cards? Is that still a modern thing to do? Give a card? How do you do it?
And I'm still like one of those nerds who spend hours to decide what kind of paper you want for a card and stuff. We've all seen American Psycho and that famous scene of people comparing cards and that sort.
And how true is the old adage that good lawyer knows the law, outstanding lawyer knows the judge? Hello and welcome to another episode of Law Vaarta's litigation series. Today we have Mr. Siddhant Buxy, who is an advocate on record in the Supreme Court and has 11 years of practice as of now. Thank you, Siddhant, for joining us. And the first question, which I always ask my guests is, how did you get here? What is your story? How did you start off in the law? Where did you graduate and what are you doing now?
Right, so I always wanted to be a lawyer. Very particularly, I always wanted to argue matters in court. I didn't know what journey will have to be taken for that, but that was my motivation. So after my school got over, I took the first CLAT, got into Nalsar, graduated from there. I didn't sit for placements because I was very anxious about being rotated through different practice areas in a law firm in the first 2 years.
Did you intern in any law firm?
I did. I'd interned in Amarchand Delhi office. I'd interned in their litigation team as well. But from campus recruitments, they would typically rotate you in different practice areas for six months. And I always felt like the moment you graduate, every second counts. So I didn't want to waste it there. Applied for clerkship. We didn't have those written exams back then. We just had a oral interview. Went through the clerkship. I had the privilege of clerking with Justice A.K. Patnaik for about a year, which was his last year in Supreme Court. Usual mixed questions of whether to go for a master's, what to do after. I figured I needed to know a little bit more about the profession before deciding. So then I applied to a law firm job, got into Amarchand, back when it was Amarchand Mangalas. Worked there for about 1.5 years in the Bombay office, but litigation team. A benefit of applying laterally after a year was that I could choose which team I wanted and not be rotated. Also ask for a particular partner. So I worked with Mr. V.P. Singh, who's in AZB now. Had a brilliant time for about 1.5 years, but realized I would probably not get to argue as much in courts, even in future. So then I shifted. I'd applied to a senior in Supreme Court. I'd interned with him in my final year. Mr. Vishwanathan, K.V. Vishwanathan, as he back then was. So I applied to him, got in, worked with him for about 3 years. Had that 5-year itch, completing 5 years after graduation. So I decided I need to start seeing how independent practice is, because it's a completely different animal. You need as much of experience, as many years to learn how to be independent by the time you reach a good age of being independent. So just jumped into the void and trust fall, as they say. And yeah, now here I am. I took the AOR exam when I became eligible, cleared it in 2020. Helped me get through COVID period rather well, because everything shifted to technology and emails, and the AORs became more relevant to have for every matter. So that worked out fine. And now here I am.
So, any second thoughts did you have while writing the AOR exam? And I ask this purely as a personal question. There is, as you said, traditional wisdom that there may be a downside to writing the AOR exam, although it is a huge professional qualification, gives you a push. Downside, maybe other people will not, other AORs will not brief you. Or there's one other disadvantage you're talking about, that
you'd be looked at as not an arguing counsel.
It's not an arguing counsel. You're only a filing lawyer. So did these thoughts cross your mind?
So, I mean, there was no dearth of these advisors back then as well. And all from the best of intentions from people. But my personal experience was that, see, I'm not from Delhi. Wherever I go to try and meet people, or even not deliberately, but if I tell anyone that, look, I'm in Delhi, I'm practicing in Supreme Court, first of all, the lack of experience in terms of the number of years would not inspire much confidence for people. Secondly, thing is, in Delhi, you go around everywhere, you 90% of the people, 90% of the lawyers you will find will say they practice in Supreme Court. So for anyone to look at, say, a young kid with 5-6 years into practice saying I practice in Supreme Court, it didn't sit well with people. But the moment you say, okay, the first question that would come straight away the moment you tell anyone I practice,
Are you an AOR?
are you an AOR? So I think it's not just for the utility for people to know that you're an AOR, that you can be of use for them. It also gives you a kind of a legitimacy to say that, okay, you have a practice in Supreme Court, or you can't not have a practice in Supreme Court.
Correct.
So I felt that, in fact, when I went independent, it took about 2 years before I could become AOR, because 1 year was the commencement period. And then you write the exam and it takes about 1 year for the result to come. So in that 2-year period, it was, I had to tell everyone that, okay, no, I'm not an AOR yet, but I'm taking the exam. Oh, I'm not an AOR yet, but I've taken the exam.
Yeah.
So it just helps. I just think it's very simple, makes it easier. And to come to your other point about how it may affect people, other AORs wanting to brief you or not. I think, and even the other fact that you might be looked at as just a filing counsel, not a arguing counsel, I think that philosophy is a little outdated now. You have more than enough evidence. You see so many number of AORs are, getting cleared every year. I've heard even this year there was a huge turnout. So AORs would, in my opinion, going forward, be the mainstay of any Supreme Court litigation practice. Not being an AOR, of course, you can always get it filed through an AOR, but if a person can directly be in touch with the AOR who's doing the work, that helps. The perception has changed that just because you're an AOR, you won't be arguing matters. I think that was that used to be the perception, but I think it's a bit outdated now. You don't find AORs who say that, okay, we'll just file, we won't argue as many. And also in terms of the future, see, I think it's not yet my time to tell you whether other AORs will brief you or not because you're an AOR, but I can tell you from the, as an evidence of that philosophy not really working out as much is the recent batch of seniors who got designated by Supreme Court. You would find an overwhelming number of AORs.
That's right.
So that gives you an indication that being an AOR doesn't really affect your chances of being a senior, and in future, if you want to be, that is. And for anyone to brief you, I think being an AOR is not really an impediment. If you have a good face value before a bench, if you're known to be good with your work, if you're known to add value, which a senior is expected to, I don't think there'll be any problem with anyone coming to you. In fact, to assuage the fears, if anyone may have any, competitive fears that someone might take away the client, there are two points that I have to that. One is that, look, you don't need to be an AOR to take the client away from someone. You can always get it filed to someone else. So that risk is always there.
Yeah.
And B, a lot of the practice of briefing people goes on the trust basis as well. So people would know it's not going to be a difficult task in that sense. And just to assuage that, many people stop filing practices when they reach that age, that experience, when they're looking to be a senior. I mean, far away, as I said, but these are just my observations, hearsay, as you can say.
Yeah, no, but very compelling, and thank you. And I think great segue into my next question also, which is because you mentioned if and when you want to become a senior. Is it true that there's a lot of worry about what is success in litigation? Is a common marker of success is somebody becomes a senior advocate? I've always had this question, as some of the people in the audience have also asked. Is that the only goal that lawyers start off with? And do you know lawyers? Do you have that goal, or if you want to share? Or is that sort of everybody's goal? Is everybody chasing that senior advocate dream? Or are there advocates who maybe like a work-life balance, who don't want that kind of a practice where they're only getting briefed and argued, who enjoy filing, who enjoy drafting and filing and want to be at that part of the process? I don't know. Or is it like a consensus? Everybody becomes a senior or wants to become a senior, and whoever doesn't become a senior is not as successful as who becomes a senior. And what's the parameter? What's your thought?
Okay, so largely I understand your seeing the common understanding of what success is, because I could identify 3-4 issues in what you asked me right now. I mean, success is as amorphous as it can get. And largely, I think people start off with a more idealistic idea of success. And as you grow older, the ideas of success become more practical. I don't know, I mean, during our college days, they used to say that if you're in your 20s and you're not a communist, you're not thinking right. And if you're in your 30s and you're not a capitalist, you're not thinking right. And I think that kind of applies at times because you do face real practical demands. So you have to redefine your priorities as you grow ahead in life. And I think if you ask me in a very philosophically loose definition, I would say success is um, having the priorities right and being able to meet them as per the priorities. That formula fits across everyone because everyone has different needs, everyone has different levels of privileges, everyone has different conditions of life. And people also have different likes and dislikes. So when you ask me, is it a consensus for people to define success as being senior? I would say no. I know quite a few number of advocates who are really, really good with their work, extremely sharp, very ambitious, but who also have made conscious decisions that they don't want to be in the arguing side of things. I know people who want to run a solicitor practice, people who want to run have the clients with them and engage seniors. We have many examples of huge practices right now which exist as well. And I do think that there are people who would want to be in that position because ultimately you want to have a good amount of work, you want to have a good amount of reputation in the court, being busy and being able to earn enough. Now, whether being a senior gets you that, being a filing advocate gets you that, what is it something you want consciously? Like for me, personally speaking, I don't enjoy the process of filing. I don't mind drafting, but the whole administrative headache that comes with filing, it is something I have to do, so I do it, but I don't enjoy it. But for some people, arguing matters in court is not as enjoyable. It is limiting for a lot of people, which is why people say even senior designations, you should time it in a way that it doesn't affect your practice. So there are a whole host of considerations. I think there's no right and wrong objectively. To each their own. Be it based on what they want to do, be it based on what their life circumstances require them to do, even if that's not their first preference. I think that's the most organic way of success. Otherwise, if you get fixated on something, maybe you might achieve it, but sometimes it comes at a bigger cost.
At a bigger cost, yeah. And one of the previous guests was mentioning that it's very easy to think of this large senior advocate dream, but you have to keep reminding yourselves that out of every 100 advocates, only a few will become seniors, and you can't keep measuring yourself against this grand ideal because there are many sharp advocates, as you said, who are very good at their work, very well earning also, but may not have chosen that path. And so don't let this YouTube idea that somebody's appearing, arguing, somebody's making reels of them, and that those are circulating. That's the only way to get famous, etc. But there are other people who, as you said, are happy doing the other things also. Connected question is, now you're 11 years into practice, and it's even for somebody who is starting out, and even for somebody who's at your experience level, I suppose everybody looks back and says, am I doing the right thing? Am I on the right path in this profession? Will this take me to whatever my parameter of success is? If it's a senior, if it's a good filing practice, solicitor practice. Is there any way in which you can sort of even evaluate this? Like for example, you're now 11 years into practice, do you have a parameter? How do I decide if I'm doing well or if I need to improve something? I need to make some changes in how I'm approaching practice. Maybe I need to network more. Maybe I need to, get out and meet more. How do you even evaluate this? Because it's so difficult to compare yourself with another lawyer who may have a completely different area of practice, clients, but who may be doing much better than you at your age, or much worse than you at your age. So, is there any way to do it, or
There's none. That's a simple answer. I used to, when I was just getting out of law school and when I just started off practice, I used to really be a pain for all these helpful seniors from college who used to be very, great mentors that I had in a few of them. But one advice that I received from someone who I still hold in very high regard as a mentor, he just put it very prettily. He said, Siddhant, every river charts its own course. That is what holds true in litigation. So there is really no parameter to compare. See, people come from all kinds of privileges or the lack of it. Sometimes, based on your life situation, you may fit in a particular place, in a particular role for better success, but you may not want to be there. People have different priorities, change with time for a lot of people. And I mean, I don't know if you guys might have read it. I started out in 2013. 2013 May, there was this one SEC journal article that Mr. Fali Nariman had written. It was a speech, advice to young lawyers. And I'm sure most of us have gone through it and read through it. But he said that, look, there is no, how do you define a young lawyer? You don't define it by age. And I think that is where the biggest misconception otherwise lies, because everyone looks at their peers. And even in your example, you let it out subconsciously that, look, someone at your own level doing better, not doing better. It's never a linear function of age. Even if, so if I have to give you specific examples, right? Let's say we are taking only two kinds of practices for now. One is a filing office, one is a senior advocate, aspiring to be senior. For people who, and this again, this is my observation, as I said, I'm like far removed from that reality. But a lot of people who get designated as seniors, they would have had a, 3 to 5 years, maybe just 3 years of regular, robust practice in Supreme Court, arguing in different courts and getting recognized for something is good enough for you to be, worthy of the recognition that you get as a senior. I mean, no one sees the base of the iceberg that's still submerged about how much work they did without getting that kind of fame or recognition. So that is one example, which again, like, you might think, okay, at some age, someone else, maybe for reasons outside of your control, maybe for reasons not attributable to merit, or maybe just out of sheer brilliance, might be getting, say, more arguing opportunities at one point of time. But that doesn't mean that you are not doing well.
Yeah.
So that is what I believe. And as a person, I've always been a blinders on kind of a person, right from my childhood, from my schooling and all of it. So if I look around too much, I don't like what I'm doing. So I just keep my blinders on and go on to define whether I am doing well or not. Because as the cliche goes, you're your own competition, right? So I mean, see, it has to be a healthy competition with yourself. You can't have an unhealthy competition with yourself, right? So as long as you are being able to meet your needs, you are not doing bad. But having said that, it is a little bit of dissatisfaction is good for perpetuity. Whatever level you reach, you can always get better. So it's just that, I mean, in terms of quality of your work, in terms of how much work you're getting, and getting work again is sometimes very outside of your hand. It's an extraneous thing. Need not be a reflection of your merit. It's, I'm sure you know about this. I'm sure people listening to me know about it as well. So
No, that's right. And once again, a great segue. How do you get work? It's just
I dropped that bait for you.
yeah. No, but I ask all the guests this grand idea of networking. Everybody says litigation में networking बहुत जरूरी है. तुम अगर network नहीं कर रहे हो तो litigation में बड़ा मुश्किल है clients लेके आना. या तो तुम्हारा कोई you have a father in the profession, or you have a great boss who's sending you matters, या तुम network कर रहे हो. यही 3 तरीके हैं briefs लाने. Network में तुम वकीलों से भी मिलो, client से भी मिलो, सबसे. But ये networking कैसे होती है? मतलब where do you go? Somebody was sending me some emails about this conference happening in Dubai कि भाई यहाँ आ जाओ, सारे वकील आ रहे हैं इंडिया के बड़ी बड़ी लॉ फर्म से. वहाँ जाना होता है क्या? लिंक्डइन पे करना होता है क्या? पार्टीज में जाना? Where do you network? How do you network? Do you give cards? Is that still a modern thing to do, to give a card? How do you do it?
So to give a card, first of all, just as a personal anecdote, so my home state is Chhattisgarh. This time in the summer break, for the very first time in my life, I stepped inside the Chhattisgarh High Court. because I felt, chalo, 11 years are done now. At least I can go legitimately, and meet people and say I'm a lawyer in Supreme Court. And you meet like seniors and people you would expect will be very old school and stuff. And I did go around. Everyone asked for my card, but a couple of old seniors who are like regular seniors, they said, "Don't give me a card. Just give me a phone number. I'll save it." Right? Or just drop me a text. A lot of people start keeping like electronic cards or something and
Correct.
just drop it around because I don't think anyone uses them.
Not
It's
yet.
good.
Not yet. But I think slowly people will.
Yeah, I mean, I still have cards, and I'm still like one of those nerds who will spend hours to decide what kind of paper you want for a card and stuff. We've all seen American Psycho and that famous scene of, people comparing cards and that. So, anyway, just on the A side, but see, networking is something that um, it's an unfortunate reality of the capitalist world. Whichever stream you are in, not just litigation, it is something that's required whether you like it or not. I'm generally on a personal level, I believe I'm fairly social, but when it comes to professional networking, I don't really, I'm not someone who has a great knack for it yet. When I was in the firm in Amarchand for about a year and a half, I got to see a bit of how polished corporate networking happens. Being advocates, of course, you can't like solicit or advertise yourself, so you have to just maybe display, give a sample of what your quality of work can be. So I remember the partner I used to work with, I used to go on some of these business development meetings with him, where he would try and gather, or either there's an event happening or he try and gather people who are of a particular industry. We'll give a presentation on the latest update on law. It's not like us telling, come to us, we'll do this, we'll do that. It's just us telling them, look, we know this much about your industry. We are invested in so much of the legal knowledge. So stuff like that. I mean, it's very sophisticated. I don't think I have any time to do all that right now. Uh, could also be because of whatever lack of efficiency. But point is, networking comes in all shapes and sizes. If you identify your relevant market, as they say in competition law terms, you can do more focused networking. But in all this, I believe, what are the reasons someone will come to you as a lawyer, right? That's a good starting point to deconstruct this. Of course, keeping aside things that are not in your control, like how you're placed in life, if you're related to someone, or if you're going to give them some unfair advantage, all that, let's just keep it aside, because that's something, if you want to get into it, then I mean, it's a very simple, fair equation, but you really would not want to get into all that. So someone should be able to trust you. You should have that level of, either a confidence in terms of uh, appearing to someone, promising in a sense. Um a lot of the work that gets given in litigation, see, either a client is coming, they're coming, keeping their, fate of their life or whatever it is in your hands. So they need to be able to get that feeling of confidence that you're not out there just to make money of them. Which, it's a very interpersonal skill, I feel. If you are getting work from other advocates, then I mean, for advocates, there are a bunch of things, right? Like as you pointed out about being an AOR, sometimes this feeling of okay, I'm not out there to get your client, and the feeling that okay, if you want a certain timeline, I'll comply with it. A lot of advocates generally engage another advocate at our level, I'm saying, not as a senior, on on the basis that they'll probably share the fees, if not recover it separately from the client. So being a little, I'm not saying don't do it for free or something, but just like be a little flexible with the advocate, because so it happens in reality, some matters will pay you a lot, some matters will pay you less. So have that a bit of a leap of faith in that sense, a bit of trust. Having said that, also be aware, if you're a young lawyer who's getting work from other advocates, that you don't get exploited in the process. If you do, don't don't be afraid to not do it at all. Take that leap of faith. It doesn't work, then you can just avoid that lawyer's work for in future, and you can get other people's work. So those are the things. I mean, in terms of networking, honestly, I don't think beyond that I can tell you much more because I honestly don't know more. Right? Like work has till now, it's just been coming from the most unexpected kind of sources. A lot of people I got work from, I had not known them at all before I went independent. So just leap of faith, back yourself, and keep trying. I guess that's the motto. Network at an event again. Now coming to your example, like conference happening in Dubai. See, I haven't attended any of those yet, so I don't know if they really make a big difference. But from my perception of these events, it maybe gets you in the picture. The very first step that people should know that you exist, you're a lawyer, you practice in this court. It maybe sometimes might give you a avenue for displaying your skills if you have to say present something in a conference. If you're just going as an attendee, meeting people, giving your cards. I mean, I'm not saying it will be completely useless, but I don't know how effective it might be for someone to have just met you. In the older times, like when I just gone independent or when I was in law school, or people would exchange cards or exchange their contact information, and after meeting they would drop in an email or a message saying, hi, it was nice to meet you, this is my contact, say with you, then keep sending whatever
Happy Diwali.
happy Diwali and stuff like that. But I think it's done to death. No one really looks at someone sending them emails and say, okay, let me give this person some work. So I think the main idea is to try and convince the other person that you will be able to do the work well, and they will be able to benefit out of giving the work to you in terms of being able to keep the client happy, quality of work, if that is good. Like as a general principle, I believe if you can just keep adding value to whatever you get. If a lawyer comes to you with a matter and says, I need a draft in this, you've come up with some additional research, you've come up with some very useful case law, they will always come back to you or at least think about you after that. So that as long as you're adding value, you are doing better in terms of networking. That's my view of it.
Right. And another connected question, because you mentioned working with other lawyers, especially as an AOR. आपके पास कोई लॉयर आके कहता है कि भाई मैं AOR नहीं हूँ, आप AOR हो, मेरा केस आप फाइल कर दो, पर आर्ग्यू मैं करूँगा. What is I have two questions. Generally, most AORs that you know, उनकी क्या अप्रोच होती है, आपकी क्या अप्रोच होती है, what is your preference, how do you file for other lawyers, as they say it, कि वो केस किसी और का है, वो आपके पास लाया है कि भाई मैं नहीं फाइल कर सकता, आप कर सकते हो, आप कर दो. तो उसमें आपका क्या प्रिंसिपल है, रूल है, या बाकी लोग AORs कैसे इसको डील करते हैं?
See, there are three situations, three broad buckets in this. I'll come to what my preference is and how it works.
Yeah.
One bucket is what a lot of times the court would remind you that being the AOR, you are supposed to do everything and be responsible for every matter, which practically, I mean, if taken it in the most restrictive sense, will close the doors for any non-AOR to get a filing done through an AOR without entrusting the whole matter to the AOR. The other extreme of it is just name lending, right? Which is, I mean, it's been critiqued to death and it still continues. And somewhere in the middle lies that gray area where I think people have a scope of shifting with time, the stance. So, see, when I became AOR, the year I became AOR was the year where the lockdown happened for the first time, 2020. In fact, during the lockdown, our results were announced. So I did get a lot of filing related work from people as well. But it was always this conundrum. So what I used to tell them at that time, as a young AOR, it's something falling in your lap, you can't say no. And you also, the first time you see your name coming in the cause list and something, it's a good feeling.
Exciting, yeah.
You see, okay, I have so many number of filings in the court. You feel like you belong a little more to the Supreme Court. Yeah. So I don't think it's something one should straight away say no to. What I used to do when I got such situations where people said, just file kar do, we'll handle it. I used to only ask them this one thing. I'd say that, look, I'll go through the draft. If I have any thing to discuss, then I'll discuss with you. We'll make changes. Let me also be satisfied with it. if you have issues of fees, then you can pay me just the filing fee. This I'll do it on my own also, because I can't just file. Being a very new AOR back then, I didn't also want to look like, I'm throwing my weight around. In the process, what happened is many a times those kind of reviews of drafts, suggestions of changes started slowly inspiring confidence to those people. So a couple of those kind of people who I otherwise didn't know of before, not someone I would have known on a personal level, they then slowly started
Just
giving
do it
me more
yourself.
roles. Then I started doing the drafts also for them. Eventually, they also said, "Ki theek hai, no fees for senior, go argue the matter." So it slowly, organically would grow like this at times. Some people would not really be comfortable with it, so you have to draw the line somewhere. There's a big risk of it at times. Like one of my matters, I had a bunch of people my age, a little junior to me, I think, who were doing the matter, and I just had to file. It started with them saying, can we file a caveat? I said, "ठीक है, caveat, file it." Matter came up, notice got issued, matter went on. Now those guys were very, very serious practitioners. Their quality of work was very good. I didn't have much complaint. I would still look at the drafts, but I wouldn't change much. And I was like, "ठीक, they are handling it. I don't have any problem." Now, in that matter, so it happened as the matter progressed that among many parties, our client, the other side, sort of settled the matter with. And once that's done, the clients lost the interest, the lawyers have lost the interest, matters over. But I'm still on record before court. I have no contact with the client. How do I tell the court what my instructions are? How do I be responsible for the matter? If anything is to be asked, I can prepare the brief and argue based on what I understand. But that's a very, very tricky situation at times. So what I've started doing is I also now tell people, look, not only will I go through the draft, I will also want to be in touch. And if for any reason you are not being able to, then you connect me with the client. Right from the beginning, I'll want to have that connect with the client, even if I'm not like directly interacting with them. So that kind of helps. And of course, now I don't tell them to just pay me filing fees or whatever, but gradually, organically it grows. But I feel that's the only way, in my opinion. If you just file, then you're always in hot water. You know.
And then
So-
everybody will treat you like that also.
Yeah,
Because
yeah.
it'll slowly build an image of you.
Yeah.
And your phone number will start circulating.
And then you start getting like multiple number of filings. You charge nominal fees, but you still make a lot of money. It's very lucrative then.
But it's name lending, and as you said, yeah. And just as another sort of avenue to grow, आपने AOR का mention किया कि that is a good professional qualification to have. When you go to somebody, you say practicing in the Supreme Court, very different from saying an AOR in the Supreme Court. Are there other ways of sort of boosting your litigation practice? Some of the traditionally advised methods are get a panel, get a retainer, build a firm, don't have independent chamber practice like you and me. What's your view? Have you ever considered making a firm? Let's tackle that first.
Making a firm, see, I would be lying if I say the thought has not crossed. In fact, past few years I've been thinking of being a little more formal as an entity, mostly to catch up with the times. I think the times are really changing fast. But my last 2 years, my inquiries have largely been about the revenue models and how that works, because I believe that's a very important thing to have sorted before you enter into a formal commitment with anyone. And I have realized that the kind of work I have, it's not a very heavily client-facing work as of now. So a lot of like Supreme Court rounds of litigation, no one comes walking into you. Other courts also that I practice in, mostly like I have practice in NCLAT, again, appellate side of practice. High courts, whatever, sometimes the clients will come, but that's not like a mainstay of my practice. So,
Sorry, you're mainly at the Supreme Court.
mainly at the Supreme Court and NCLAT and High Court and some arbitration. These are my defined areas now, which was I'm sure you must be going through that stage of confusion right now. I've been through it as well. So we'll come to that, I think, later in the interview. So, see, for my kind of practice, since it's a very relation with another advocate, and you don't have any certainty how much fees every matter will get. You make your schedule of fees, but you always tell them, okay, it's tentative, whatever. It's
Yeah.
And nature has its way of subsidizing. Sometimes in need for needy people, you will be doing a lot of work for less money, and suddenly you will get some rich client which will not bother showering money on you. So all that happens. So for those kind of uncertainties, I have felt that a eat what you kill kind of a model works well, where you just share the administrative costs and share the working space and chamber. So, I mean, that's just, as of now, it's an ongoing process. I have not yet formally done anything. But to add to your traditional advices, as you mentioned, there's one more. I wouldn't say if it's a traditional advice, but it's a lived experience. You can also choose to marry someone who works in a law firm, who can support for the first few years.
Yeah.
Which happened with me. So I mean, that was again something pre-planned in a way, like when we were getting out of law school. So that was the idea, and I mean, she did her part and then exited the law firm and started her own practice as well. Otherwise, on terms of panels and retainers, again, luckily for me, Priyanka got a very good retainer when she went independent. I would be, really lying if I take the credit for the fact that I've managed to have my own practice all by myself. That's been the biggest sort of help in that sense. Retainers do really help because they give you that financial certainty. And for a lot of people who come from, service class families, getting out of this mold of a monthly income is the biggest challenge. You have to start looking at it from a quarterly, annual, semi-annual perspective, because otherwise you just die of anxiety.
It makes no sense because you don't get your fees monthly.
Yeah, that's the uncertainty. So retainer provides you that balance if it's a monthly retainer, which mostly retainers are. How to get them, I have no idea. Otherwise, I would have got a couple of more. Priyanka got it because the same client she used to work for in the firm when she was there. So they just continued with her on retainer in addition. So that worked out well. Panels, I haven't really looked into much, but my idea behind it, and it's been a bit of a conscious decision. Panels give you a good volume of work. They give you good certainty in terms of finances, but they also come at an opportunity cost where if you've got it too early, there's nothing else you can do. Like I've seen it a little bit with Priyanka as well, with her retainers, giving her that fear that, okay, this might become a permanent mark or I'll just be known as this lawyer, Like you have seniors also right now in Supreme Court who will be known as a particular lawyer for the panels they used to represent before. So I think you take a panel mostly to get more exposure in court, more chances to argue in court. So if you time it well, when you can capitalize once the panel is over, I think it might be a better point. Government panels, I'm not sure how well they pay. Retainers are better to pay. Panels are good for getting more quantity of work. I don't know if they're good for getting enough pay.
And appearances in court, perhaps.
Yeah, which is why I feel that once you reach that position where you can take that that gamble, that okay, large part of your work will be large part of your energy and work and time will be utilized for something that may not pay a lot or not pay timely. Governments don't pay in a timely manner. So I think you need to be prepared to be in that position if you take those panels, even if it's a PSU panel or whatever. Have enough resources in your office that you don't get burdened by their work alone and not do anything else.
Right. That makes a lot of sense because till now everybody has been saying good things about get panels because they get your appearances. But I think that's a very valid consideration. If you rely solely on that, if your monthly income doesn't come, you still have to pay your.
Correct. And just as a segue to that, I'm borrowing your language now. But see, I on a personal philosophy, I believe that if you make space for things, then things come, and that's also one way of assuaging your business development networking fears. That you just manifest things and you keep yourself prepared for it. Because again, going back to that 2013 speech of Mr. Farid Nariman, one of his 3 advices is he said, for practicing lawyers, I will say follow the Boy Scouts principle. Be prepared, always be prepared. So you can't, I think if you're just burdened by one panel work, you will never be prepared or ready or have space for anything else to come in. So if you're willing to accept that, great, nothing wrong with it. I just personally, I feel that maybe I'll want to wait a little longer.
Yeah, no, that makes a lot of sense. And any other ways of, I think you mentioned very wonderfully that you've always been with blinders on, that you don't look here and there so much. But generally, any ways, maybe technology, maybe anything else, to have an edge over, maybe not over others, but over your past self.
Yeah.
How can I grow? And uh, what are some of these ways? What are some things that maybe maybe some other lawyers are not doing right? In the sense that I don't mean that they're doing something wrong in the sense of morality, but something they've not yet picked up, something they should be faster to catch up to if they want to sort of speed up their process in the career.
See, if you are asking this question, it answers apply based on what setting the lawyers are in. If you are like a court practicing lawyer, Supreme Court, running a AOR practice as a counsel, I think some soft skills really help. Large principle, I mean, the overarching principle of it is to increase your efficiency, because that is what can help you do more work, right? And I think people, if they embrace technology now, I mean, thanks to the current CGI, there's a lot of push for paperless offices. I remember I had started using liquid text before the lockdown, and
You must be the first buyer of
no, I wasn't the first buyer. See, frankly, my very close friend and chamber colleague Ravi had told me about it, because his erstwhile senior from the Madras High Court, Mr. Satish Parashan, used to use it.
Wow.
Back before the lockdown. So I just checked it out and I really liked it. I moved on from it now. I moved on to PDF Expert. I feel it replicates the physical brief better than the liquid text, but to each their own. But I am always on the lookout. There's I don't know if you know Mr. Yogesh Ravi. He's a practitioner in Supreme Court. Phenomenal guy to take any technological advices from.
I see.
So he runs a blog called Sans Paper. That blog helps you digitize your office and move into as a technology practice. When we meet in court, like we're talking about what's ailing us, what's really frustrating us. So I had once had a huge discussion with him on this whole liquid text PDF expert thing, and I used to be a huge proponent of liquid text, but now I've shifted because I started seeing what whatever points he had to say about it. His blog's very helpful. I mean, I found it to be very helpful, and I always look at him, and I mean also the general technology world to see what's advancing. Like, I remember last term I had a conversation with him in the canteen, and he showed me how he programmed, made his code in ChatGPT to take dictation. So now he can dictate on his phone and it gets typed in the SLP format.
Wow.
He's programmed it to accept South Indian names easily without misspelling.
Yeah.
He can tell them, put this between this and this in questions of law, and it will do it. It's like,
I would like to call this gentleman.
You should. I think we all would greatly stand to benefit. In fact, this summer break I couldn't do it, but my task was to really figure out how to get a hold of AI, because I mean, I think we lag far behind. The rest of the world is really caught up with the whole GPT-4, Llama 2, and whatever it is. There are so many AI bots for lawyers specifically. There's one Harvey, I think, in the US.
Yeah. But so far, I mean, I've tried some of them, but I haven't really found them to be very useful. But I'm particularly interested in everything you're saying, because I also keep using ChatGPT for Python coding and all.
I'm pretty I'm very lame about this. I don't know much about the AI yet. I've just started reading a few books on it. So hopefully I'll catch up on it as well. And
but I would love to sort of even see the blog for sure, and maybe perhaps have a chance to meet Mr. Ravi.
And to invest in these softwares is a very useful investment. They appear to be a little costly initially, but my office right now runs paperless, except for when the court requires it. Like NCLAT has this requirement where you have to also file physically. So those are there, but I think by now we've all lost habit of reading physical files. It feels inconvenient. Then you keep carrying it, flipping pages instead of just touching your bookmarks. So I think it really helps, and it also helps great deal in utilizing your time while waiting for matters in court. Like, there's one, debts, taxes, and waiting for matters, and lawyers complaining about waiting for matters. These are four certainties of life. Now, when you know it's such a certain thing, if you can have your entire office in your sleeve with a laptop, iPad, or both, whatever you can use, tablet, and if you can just sit and work on anything anywhere, Supreme Court has internet. So I think that these are things that give you advantage, and it also helps you in maintaining some sort of a work-life balance. If you can just utilize your time during the day, you don't have to sit too late, and just like waste time during the day and work during the night. I mean, that's the aspiration. Doesn't happen, but possibly. So these are the things I feel can give a bit of an edge for people working in different settings, like being in a law firm. I don't know how much to comment because those guys are already doing quite well, I guess. Um, yeah, I mean, I think technology is what I would probably focus more on if you want to have some edge in terms of work. And of course, the age-old advice of reading as much as you can. I mean, if you don't like, if you have time, and I, in fact, also from experience feel that while reading, one should mix what you read because you can get fatigued with just reading judgments in the law. If you don't know what the world otherwise is, how do you apply law? So I don't know.
This just reminds me, late Justice U.S. Justice Kalya, in one of his speeches, has said, if you want to be a good writer, first he says there's no such thing as legal writing.
Yeah,
There's only writing
that
about
also
the law.
imply illegal writing.
Yeah, but he says it's not specific to law. It's just good writing and bad writing.
Correct.
And he says most people who are bad legal writers are bad because they write badly, not because they don't know the law. I says that's because you only read judgments. Because most of them are terribly written. And he says they are not taught in law schools because they are well written. They are taught because they are authoritative.
Correct.
You have to know them. But if you want to be a good legal writer, you read other stuff outside the law. Yeah, so something very similar to what you were saying. So I just,
No, so I think these are the two things I can say can, in my limited view, can give you some edge.
Yeah. And I think finally, just to close the conversation, I want to also ask about the court generally, because a lot of things are unknown to early career litigators and final year law students or so about how the court really progresses. There's this, like you said, I think everybody who ventures into litigation, उनका शुरू में ख्याल यही है कि मैं आर्ग्यू करूंगा या करूंगी एट सम पॉइंट. एक केस में कितनी डेट्स पे आर्ग्यूमेंट होता है एंड कितनी डेट पे इट्स जस्ट अ मिसलेनियस वन सेंटेंस टू सेंटेंस, I'll file this, I'll file that. And how true is the old adage that good lawyer knows the law, outstanding lawyer knows the judge? How much is it dependent on judges? But how much, I mean, because I've heard extreme opinions about this. Some people say judges are everything. अगर मतलब सिर्फ जज से डिसाइड होता है कि आपका केस कैसे डिसाइड है. एंड द अदर एक्सट्रीम इज इट्स नॉट रियली सो दैट ओल्ड अडाज इज ओवरडन. ऐसा कुछ नहीं है कि जज पे ही सब कुछ निर्भर होता है. वो जज ठीक है 19-20 का फर्क हो सकता है बट उससे ज्यादा नहीं हो सकता. बट हाउ मच डू यू थिंक दैट मैटर्स? इज इट ट्रू दैट वी हैव 17 सुप्रीम कोर्ट्स और इज इट do we have only one? What's your view?
I don't see a dichotomy in the two things that you mentioned, to be very honest. I think judge is everything, covers it all. Because if you believe that, okay, you should know the law and that's enough, and what the judge feels is not relevant, then perhaps you're talking about a judge who only looks at the law and nothing else. So eventually it all comes within that umbrella of knowing the judge well. But if you don't know the law well, then knowing the judge well enough is not sufficient as well. Right? Because if you don't, like, I mean, if you're in a high court, for example, and you have Supreme Court judgments that bind you. So if you know a judge may not be comfortable with what your argument is, you can always support it with authoritative judgments and you at least bind them or build grounds for an appeal. Supreme Court, of course, as you mentioned, I mean, I think more than enough number of people have said it. It's final. It's a court of finality. It may not always be correct. We all know about it. 17 Supreme Courts. I would say maybe if you look at the whole case statistics and how courts operate, maybe not full 17, but yes, I mean, wherever there is discretion, there is always a room to differ. As far as the laying down of law is concerned, which is ideally the Supreme Court's role, there 141, I mean, see, no one will, if people pass conflicting judgments on law, then of course you have the whole remedies of larger benches and all. So there is a structural safeguard against it. But if on application of the law to similar facts, the judges are deciding differently, then I think, I mean, it's not really. Of course, it's very frustrating. That's when you need to know the judge. But it's not always a wrong precedent at times, because a lot of the law is laid down where it says, okay, it'll depend on the facts and there'll be some minor differences sometimes. There are, of course, situations where identical facts, judges might differ. Maybe a precedent is not shown, maybe a judge is not willing to see a precedent. So that scope is there, possibility is there, and time to time it happens. But on a large scale, I don't think it's like a chaotic world in Supreme Court. It's not so, I think. Uh, See, it's just as a professional hack, I feel as a client, one should, like, when you're dealing with a client or dealing with someone who's coming to you with a matter, I think it's a great way to convince them that it's all wild, wild west. But as a lawyer preparing to argue the matter, I don't think that's a good way to go about it.
That's a fantastic way to look at it. Two perspectives. Yeah. And how about how many times does argument happen? What does the courtroom proceeding look like? Even in a day, if the court has 60 matters, how many are going to be heard on the merits?
So it depends on the day of the week. It depends on the court you're talking about. If we take Supreme Court, for example, point is you have to be ready. You never know. Only on the days when you're not ready, your matter will reach for hearing. If the matter reaches Supreme Court, can always finally dispose it off at any stage. It's not a certainty. I have seen matters where without pleadings being completed, the judges are like, okay, the pleadings are there from the lower court. What more do you have to say? So that possibility is always there. A lot depends on luck, of course. And in every given situation, there will be one of the two sides which will stand to benefit with an adjournment, either to avoid a dismissal or to gain some other advantage. So that risk is always there. In other courts outside of Supreme Court, I feel adjournments are far more frequent and far more easier, which sometimes it is very irritating. As a lawyer, you prepare and go, and then it becomes challenging to keep preparing every time, and then you start getting this feeling of despair that okay, nothing's gonna happen, kuch nahi hona hai isme, adjournment hi honi hai. Why should I waste my time? Why should I not do something which gives me better joy than to just sit and read this again that I've read 10 times? But that's a systemic problem, and I think with the times to come, I'm quite hopeful this will reduce. I'm quite hopeful because newer judges are far less likely to give you adjournments, far more courageous to dispose things. And Supreme Court, I think, in that sense, can be a good guiding court. Like if that's the practice being followed there, like how we've all now. I mean, it's a very controversial thing that you've stopped circulation of letters, but I can tell you it's very reassuring in one hand because as a lawyer, if suppose the other side circulates a letter in my matter, I know that it's up to the judge's discretion. So I have to still be ready, right? And if it's a big stake matter and the client only wants a senior to appear, then you have limitations on the amount of fees to take. Other side circulated a letter. Why would you take a senior and suffer their fees? But what if the judge hears it?
Correct.
It used to put you in that state of uncertainty. Sometimes they will serve you the letter, but the letter would not have been circulated by the section to the judge's files. It happened, all these things. So I think the system, the way it was, it's great that they've taken it away, but for legitimate concerns of adjournments and all, I think the courts are fairly reasonable now. So to answer a question, to conclude, one should always be ready and prepared that the matter may drag on for very long, but always be prepared that it can just get disposed of anytime. It's a tricky situation. There's lack of certainty. I wish we could be better managed. Like we all have, I'm sure, over the period in Supreme Court practice, we've all at different points of time idealized about, okay, one should have time limits, one should have those buzzers like the US courts. These arguments just keep going on and on, but I mean, it all has to start from the judges. And I think the judges have been fairly strict. Last few constitution benches, the chief was very strict about the timings, and one person's covered everything, you have it in written. Better pleadings help a lot, absolutely help a lot. If the pleadings are to the point and you've covered your points, they really reduce the amount of time. So the shorter a case takes on an average, the more likely your matters are to reach for hearing.
And it is all about the system. It has to come from judges. Thank you so much, Siddhant, for joining us today. And if you have any questions or comments, like always, please do drop them in the comment box, and we will take them up for our future episodes. Hope you enjoyed the episode. Please like, share, subscribe, the usual. Thank you so much. Thank you, Siddhant.
Thanks, Jitendra.